Welcome back to this final segment of this law session on the structure of government, the House of Commons and the House of Lords. Now in this final segment we will explore, of course, the House of Lords, but before we do that, before the break, I said to you we need to consider the interplay between the Commons and the Lords. Now in the last segment I did flag up that when you look at the Commons, it is the main house, and it is the main house precisely because the members, meaning the members of Parliament, are elected. Now, when you look at the whole legislative process, it is a bicameral chamber. You do have the upper house, which is the House of Lords, the lower house, the House of Commons, but of course the main house is the House of Commons. But the House of Lords is also involved in the legislative process, and in holding the executive to account, we do see that the Lords play some part as well. When you look at the framework, though, it does give some, I don't want to say rise for concern, but it is something for you to take on board. When you look at Section 1 of the Parliaments Act 1911 and 1949, there has been some degree of friction between the House of Commons and the House of Lords. What we've seen, for example, is that when it comes to money bills, these are certified by the Speaker as containing provisions relating exclusively to central government taxation. Now, Section 1 provides that if the Speaker certifies a bill as being a money bill before the bill leaves the Commons, then it may be presented for royal assent even though the Lords has failed to pass it without amendment after it has been before the Lords for at least a month. Now, Section 2 of the Parliament Act 1911-1949 looks at bills other than money bills, and Section 2 says that such a bill, other than money bills, can be presented for royal assent if the bill has passed by the Commons in 2 consecutive sessions, whether of the same Parliament or not, in the same form, or subject only to such amendments as they were certified by the Speaker as being necessary through the passing of time. Now, it continues that the Lords, if the Lords has failed to pass a session in each of the 2 sessions, and 1 year has elapsed between the second reading of the bill in the Commons in the first session and its third reading in the Commons in the second session, then the bill is sent up to the Lords at least 1 month before the end of each session. Basically, what it is saying is that the Speaker can certify that the Act has complied with the Parliament Act and is therefore eligible for royal assent. What does this mean? It means that an Act of Parliament can pass without the input of the Lords. It means that an act out of the House of Commons, which is a money bill, generally can pass by sitting for a month, others for a year or over 2 sessions. But the point here is, as a law student, what I want you to ponder is this. Number one, what is Parliament? If Parliament is supposed to be the Lords and the Commons, then how is it that an act can be passed if it has only gone through the Commons? Does that mean that it is not an act of Parliament? Because what is Parliament? It is a little bit circular, but I want you to understand the concept. Remember, parliamentary sovereignty talks about an act going through Parliament. But when we look at the Acts of Parliament, it is that an Act of Parliament can legitimately be passed where it has not been to the House of Lords. As such, arguably, you're looking at an act coming through a unicameral chamber. So is there an argument that even though there is the appearance of a bicameral chamber, the reality is that the UK has a unicameral chamber, precisely because the House of Commons can pass an act without the input of the Lords? Now, this parliamentary procedure has more or less been used fairly infrequently to pass, and we've only seen a few areas or a few circumstances where this has, and the one that springs to mind, of course, is the Fox Hunting Act, where the Lords were very reluctant to pass this, and of course it went through regardless. Now, when you look at the mandate that then government had, it was going to go through regardless. The fact of the matter is, once the bill gets the royal assent, whether or not it has gone through both houses, the fact is it becomes law. It cannot be challenged, and that is what it is. Now, of course, if you're going to get highly technical and you're pushing for a first, now here's the point. Is it, or can it be suggested that the Parliament Acts, as they stand, are not really acts of Parliament because they did not go through the process to make them an act? Again, I say that it is a technical point, but it is an arguable point to suggest that, well, what is an act of Parliament? What makes it an act of Parliament? What we do see and what we do know, of course, is that the House of Commons is, of course, the main house. And as long as it goes through there, then that more or less will be the driven agenda. So what is the point of the House of Lords? Who are they? What do they do? Well, they are the upper house of Parliament. It is independent from, but it does complement the work of the House of Commons. Now, the Lords share responsibility for making laws, checking government action. Bills can be introduced into either the House of Lords or the House of Commons, and members of the Lords may also take on role as government ministers as well. Now, unlike the elected House of Commons, most new members of the House of Lords are appointed. Now, membership of the House of Lords is made up variously of Lords Spiritual, Lords Temporal, and temporal means time, of course. Spiritual, of course, to do with the churches. Now, there are currently 26 Lords Spiritual who sit in the Lords by virtue of their ecclesiastical role in the Church of England. Now, as it relates to the Lords Temporal, they make up the rest of the membership, and of these, the majority are life peers who are appointed by the monarch on the advice of the Prime Minister or on the advice of the House of Lords Appointments Commission. Now, it used to be that membership was a right of birth, and as such you are a hereditary peer, you are a hereditary lord then. But there were a series of reforms, and by 1999, we get a dramatic reform in the area of the House of Lords. And what we have standing, of course, is only 92 members. Well, as of 2011 anyway, only 92 members of the Lords were hereditary peers, meaning they're there by virtue of their birth. Now, the numbers of the House of Lords is not fixed, unlike, of course, the House of Commons. Now, as at summer 2012, there were approximately 775 members. Now, as I say, you have fixed membership in the House of Commons. The House of Lords, of course, provides certain expertise, and it does scrutinize bills that have been approved by the House of Commons. It comes into the House of Lords and goes through its own procedures. Now, it's regularly it acts regularly as reviewing and amending bills from the Commons. The point for you as a law student, though, is that when you look at the House of Lords, it is not elected, but it wields power. And the point to take on board is that there, in all of the reforms, when you go back, House of Lords reforms didn't start in 1999. As a student, please do not make that mistake if you're going to write an House of Lords reform. House of Lords reform did not begin in 1999. That's when we see an act which reduced hereditary peerage, but we certainly can go back to the 19th century to look at this. But when you look at the House of Lords, they are appointed, yet they have this power. Question, should they be elected? The problem, of course, is if you start having two elected houses, does this not give rise to some sort of power struggle? And that's one of the things that has caused a little bit of problems as well. Because on the one hand, we see the House of Commons saying at times, oh, we would rather them be elected. the House of Lords stands its ground, and the majority in the House of Lords is saying we would rather be appointed. What you've got to consider is the House of Commons making the right move by saying go for election? Because if they're elected, might that not then impact on even the ability of them being able to pass laws without the input of the Lords? Because if it is that these persons have now been elected by the electorate, their voice will be stronger. The main reason the House of Commons is the main house is because they're elected. If you've got two elected house, then where do you go? All right, let's look then briefly at the background of the House of Lords. Well, as I said before, we see that the House of Lords it's not just recently this has all come into being. In 1911, we see the Parliament Act 1911, which limits the powers of the House of Lords. And there we see that the whole idea of them being restricted when it comes to money bills had been put on the table. We also see that the Parliament Act of 1949 also had some impact. So the Parliament Act of 1911 and 1949 can generally prove to be a useful starting point when you start talking about reforms. But let's go back a little bit before that even. Well, in the 18th century, what we have is a single UK Parliament being established, and between 1886 and 1888, we have the Commons debates, and we have the hereditary right to sit in the Lords. By 1893, we see Gladstone's Home Rule Bill being defeated, and this is because there appears to be this political imbalance in the House. And by the end of the 19th century, the House of Lords is represented by hereditary peers, representatives peers from Scotland, Ireland, certain noblemen, bishops, and of course, the Lords of Appeal in Ordinary, which have now, of course, been taken out and now sit in the Supreme Court. By 1907, we get a report from Rosebery, termed the Rosebery Report, which recommends how peers should be selected in the Lords. 1907. But we see no action being taken on the report. By 1910, we see the Liberal government proposing a strong and efficient second chamber, but what happens is there's a failure to agree on the degree of power that ought to go there. Now, by 1911, the leader of the opposition proposes that members should be indirectly elected in a bill, which is later on then dropped. The bill, nothing goes further. And it is in the Parliament Act 1911 that we, of course, see this restriction in relation to money bills. By 1918, we see the Bryce Report outlining proposals for functions and structures of the House, and it looks at examining and revisions of bills and just general questions of policy. However, we see the government getting preoccupied with war. Nothing else happens in the context of reform. By the early 1920s, of course, the King mentions this idea of reform in 3 speeches. The government puts forward some resolutions, and one of them was that hereditary peers be elected by their own order. And what we see is, again, the debate being adjourned, nothing happens, and this goes on right up to around 1927. Between 1929 and 1935, there are various private member bills which look at live peers and whether this is something that needs to be withdrawn. Now, by 1949, the Parliament Act dealing with the powers of the Lords becomes law and updates the terms of the 1911 Act with regards to the vetoing of certain bills, as we say when you look at money bills or bills where it passes certain numbers of sessions. By 1958, we see peers who do not or are unable to attend the House can apply for a leave of absence, And we see the Macmillan government, of course, initiating the Life Peerages Act of 1958, which gave the Crown authority to create life peers. And this, of course, included various people, including women and various others, of course. By 1963, there's another act, and we move on, of course, 1968 to 1969. This is where we get a white paper relating to House of Lords reform. And by and large, we do get this being debated and abandoned, and debated and abandoned. And you do get some activity. And where you really see any real push is around 1997, where after the general election, the Labour government announces a bill to remove the automatic right of hereditary peers to sit and vote in the House as the first stage in the reform process. And then we see the House of Lords Act in 1999, and it certainly reduces the more than 600 persons sitting there, and we see the 92 hereditary peers being put in place, and that's pretty much where that number in respect of those peers have remained. Now by 2000, we have the Independent House of Lords Appointments Commission is established to recommend and approve suitable candidates for membership. In 2001, the Queen confirms her intention to create 15 new non-party political House of Lords members, and the reform continues. Now, what you have to look at is in recent times, between 2010, 2011, 2012, we have seen some changes. We have seen that House of Lords reform was one of the mandates, as it were, that the Lib Dems were concerned with. And as such, we have seen them putting forward a bill, because the point is that House of Lords reforms has been put forward, it has been taken back. In 2007, the government advances a white paper again to look at the structure. It wanted a 50% elected member, a 50% appointed member. Unfortunately, the proposals then from the House of Lords is that maybe they should have a 20% elected member, 80% appointed. We see the House of Commons seeking an 80% elected and a 20% appointed. And there's this, it simply is that there can be no agreement as to how the reforms should take place. It has caused various discussions simply because there cannot be any agreement. And at one point, again, if you read the recent reports and read news and so on, you see that there has been some frustration in the coalition government, because we see the coalition government in 2010 publishing an agreement saying a group would be appointed to bring forward proposals for an elected House of Lords, and the group was supposed to be comprised of certain front bench members. In 2011, there was a draft bill, but by the time we get to 2012, of course, the Joint Committee on the House of Lords, Draft House of Lords Reform Bill publishes its report, and what we see is the whole thing has now more or less been abandoned. What we see is that the House of Lords reform and the debate on it, by August 2012, we see the Deputy Prime Minister, the Lib Dem, announcing that legislation in relation to the reform of the House of Lords has been dropped, and there's a statement then withdrawing the House of Lords reform bill. As it stands today, there is no reform from where it was last left. What you need to look at is especially 2002, 2007, 2010, those were the main ones where they had advanced some idea of what should be the makeup. What you need to do as a law student is, which one do you think would work? But what you have to bear in mind is, if you're going for election, what would be the impact of the role of the House of Lords in relation to the House of Commons? That brings us to the conclusion of this law session on the structure of government and the House of Commons and the House of Lords. Certainly, if you're signed up to our premium service, I would certainly encourage you to explore this further in our discussions.